Hello everyone, I am Grace Navakoza and I am the Head of Employment Relations and Legal at the Federation of Ugandan Employers. In this video, we would like to talk about the 4 things that the Industrial Court wants every employer to know. You realize that over the years, there has been established the Industrial Court and since 2015, and we have had quite a number of challenges in regards to terminations. We have had a number of discussions, a number of even awards that are really shocking to the employers. So we would like to explore what are some of those key things that you need to know as an employer. The first thing, the employer needs to ensure that each and every employee at the workplace has an employment contract. You also need to ensure that at all times you have a running terms and conditions of service for these employees, right from the time you hire them, what they're entitled to during employment, and how you will end the employment relationship. So it is very important, because you wouldn't like to have the Industrial Court trying to interpret issues for you that you left vague. That is why it is very important that you have an employment contract. If it has ended for any employee, you renew it, okay? Depending on the circumstances. The second thing is that you need to ensure that while you are ending this employment contract, it is done in a lawful way, in accordance with the employment laws of Uganda, but also done fairly for the employee. When we mean fairness, it means what is reasonable in the circumstances, what any reasonable employer should have done in the circumstances. And what is lawful means that you have followed all the precautions, all the requirements that are required, that are stated in the Employment Act. Now, you realize that over time, we have had instances where employers are told this termination was unfair, this termination was unlawful. So what we mean is that you need to have the termination in writing, meaning that nowadays you cannot terminate an employee verbally, okay? So put it in writing and have a reason for the termination. Why are you terminating? Is it because the contract has ended? Is it because of a disciplinary misconduct and you held a disciplinary hearing that eventually led to the termination of this employee? So in other words, you need to ensure that the termination was lawful and was fair to the employee. Now, you realize that there are a bit of gaps in the employment laws, but there are a number of instances where the Industrial Court has come out very clearly and has guided employers when it comes to redundancy as a means of termination. What are those key things that you need to know as an employer? So we employ you again to keep reading some of these judgments. Ensure that your legal teams, your HR departments are having access to some of these decisions to guide you appropriately on what are some of the procedures that you need to take, that you need to observe, that you need to state in your terms and conditions of service to enable you ensure that the terminations you carry out are done fairly and equitably. The third thing is you have to ensure that the employee gets terminal benefits. Of course, the word terminal benefits keeps confusing employers and even employees, but it means that what are some of those things that the employee is entitled to at the time of exit? Some of these things are specified in the Employment Act. When we mean the Employment Act, we're speaking about that one of 2006. Now, there are certain circumstances where the law has come out specifically to say that an employee will be entitled to some of these terminal benefits. Terminal benefits is a collective word that you, an employer, need to know and put in place those particular allowances, entitlements that an employee is entitled to at the time of exit in employment. For instance, the law talks about repatriation, but also puts in place circumstances under which repatriation will be paid to an employee. I'll employ you to look at Section 39 of the Employment Act, 2006. The second would be severance. severance pay. It means that now you also need to look at the circumstances under which severance will be paid, because that is also specified in the law. So if you terminated an employee under those circumstances specified in Section 87 of the Employment Act, it means that the employee would be entitled to that severance pay. Many times we get confused on the issues of salary. Of course, an employee who has ended their employment or who has been terminated will have to be paid their last earnings, even if they have just worked for days in a particular month before the termination took place. They will be entitled to the salary of those days or that particular month for which they worked. The most important of these terminal benefits is the notice. In other words, you are notifying the employee that please be informed that your termination is going to take place on this particular date. The notice would be advisable to give physically, but in instances where you are constrained as an employer to give this notice physically, it means that then you have to pay in appropriate salary. So you need to take a note of those terminal benefits. But of course, there are other employers in their terms and conditions of service who provide for other terminal benefits that you as an employer need to observe. Okay, so it becomes a case-by-case basis. But there are those that are legal that we must give, which include the salary last earned. Okay, it includes repatriation if an employee qualifies under Section 39, and includes severance if the employee qualifies under Section 87, certificate of service under Section 61 if the employee really requests for it. But out of goodwill, you can choose as an employer to give those terminal benefits. The fourth and the last is you need to be cautious when you are giving introductory letters, reference letters to employees who are going to access loans from the bank, because we have over time seen situations, and increasingly the industrial court has affirmed its decision, which has also further been affirmed by the Court of Appeal, saying that an employer who gives a letter of introduction to an employee to go and access a loan from any commercial bank, and the employee says that the loan will be repaid from this salary, and then you unfairly terminate this employee. It goes back to our point number 2. Remember, point number 2 says you have to terminate fairly and lawfully. So if you terminate unfairly and unlawfully, and that is the finding of the court, and yet you gave an introductory letter to an employee to go and access a loan from a bank, it would then mean that you as an employer, you are supposed to pay for this loan that the employee accessed. The rationale behind this is the employer wants, the court is interested in knowing that if at all you had not terminated this contract unfairly, the employee would probably be in employment and would continue paying for this loan. But because you cut their employment short and you did not carry out the termination fairly, it means that then now the burden comes to you as an employer to pay for this loan. So ideally, what we are saying and what we are imploring you as an employer is to keep in the habit of reading these awards, keep understanding them, seek clarity as an employer. Your teams or your management teams should be able to seek understanding in case some of these awards or decisions are vague, so that you carry out your terminations, you carry out your processes and procedures in a fair and an equitable manner to be on a safe side of the law. There are a number of things that the industrial court would want you to know as an employer, besides the 4 that we have talked about. We implore you to get in touch with the Federation of Ugandan Employers in case you need any more information or further information. We are more than willing to assist and guide you.